What is the price of a life? If you were adrift in an open boat, starving, dehydrated, and facing almost certain death, and the only way for three of you to live was for one of you to die, what would you do? This isn't a hypothetical. It's the brutal, real-world dilemma that shattered the lives of four men on the Yacht Mignonette in 1884, a dilemma that forced the entire British legal system to answer a question we still wrestle with today. Does survival ever justify murder? Before we dive in, a quick note. This video is an educational and analytical discussion of a historical legal case. It involves descriptions of survival cannibalism and a killing, but it does not promote violence, hate, or any extremist ideology. This is not legal advice. It's a deep dive into a story that forces us to think about law, morality, and the limits of human endurance. In the spring of 1884, a wealthy Australian lawyer named Jack Want bought a small 52-foot yacht named the Mignonette. It wasn't built for ocean crossings, but he wanted it sailed from Southampton, England, to Sydney, Australia. He hired a crew of four: Captain Tom Dudley, First Mate Edwin Stevens, able seaman Edmund Brooks, and a 17-year-old cabin boy named Richard Parker. Parker was an orphan, excited for his first real sea voyage. The voyage was uneventful until July 5th, 1884, about 1,600 miles northwest of the Cape of Good Hope. A massive wave struck the yacht, washing away part of the bulwark. Dudley realized the ship was doomed and ordered the crew into the lone 13-foot lifeboat. They had barely enough time to grab 2 tins of turnips and some navigational instruments. No water. The Mignonette sank in minutes. So there they were, 4 men in a flimsy open boat, hundreds of miles from the nearest land, with almost no food and no fresh water. They rationed the turnips. They caught a turtle, which gave them some meat for a few days. They tried to catch rainwater, but mostly failed. Soon they were drinking their own urine. By around July 20th, the cabin boy, Richard Parker, desperately thirsty, drank seawater. It made him violently ill. He lay in the bottom of the boat, weak and likely dying. At this point, Dudley raised the custom of the sea, the ancient, grim tradition of drawing lots to select someone to be killed and eaten so the others might live. The discussion went on for days. Brooks refused to participate. Parker, of course, was in no state to consent. On July 24th or 25, with Parker seemingly comatose, Dudley and Stevens made a silent agreement. Dudley said a prayer, then used his penknife to cut Parker's jugular vein. They collected his blood in a chronometer case and drank it. Then they butchered his body, eating his heart and liver first. 4 days later, on July 29th, they were spotted and rescued by the German bark Moctezuma. When they landed in Falmouth, England, in early September, Dudley and Stevens were candid about what they had done. They believed the custom of the sea and the sheer necessity of survival justified their actions. But the local police sergeant overheard their story, and the legal machinery began to turn. Dudley and Stevens were arrested for murder. The trial that followed was, in the words of legal historian Brian Simpson, procedurally a complete mess, but its outcome was deliberate and profound. The judge, Lord Chief Justice Coleridge, instructed the jury that necessity is no defense to murder. The jury, reluctant to condemn the men to death, returned a special verdict that kicked the question up to a higher court. A panel of 5 judges unanimously affirmed the conviction. Dudley and Stevens were guilty of murder. They were sentenced to death, though with a recommendation for mercy. Public opinion was largely on their side. Even Richard Parker's own brother shook their hands in court. In the end, the Home Secretary commuted their sentence to 6 months' imprisonment. They were released in May 1885. That's the bare timeline. But if we stop there, we miss everything that makes this case matter. This isn't just a grim tale of survival. It's a legal, philosophical, and human detonation that forces us to ask, what is the law for? What do we owe each other in extremis? And why, nearly 140 years later, does this story still grip us? The central legal question in R versus Dudley and Stevens was stark. Can the overwhelming pressure of starvation excuse killing an innocent person? The defense argued yes. It was a matter of inevitable necessity, a tradition recognized by mariners for centuries. The prosecution, and ultimately the court, said no. And the reason why tells us a lot about how law sees itself. Lord Coleridge's judgment is a masterpiece of moral rhetoric anchored in legal rigidity. He acknowledged the awful predicament and the terrible temptation the men faced, but then he laid down the rule. A man has no right to declare temptation to be an excuse. The court rejected the idea that necessity could be a defense to murder for two core reasons. First precedent, the judges looked at earlier cases, like the St. Christopher case from the 17th century, or the American case United States versus Holmes, and found they either weren't properly recorded or didn't establish a clear common law defense. The law, in their view, had never officially sanctioned killing an innocent to save oneself. Second, and more profoundly, a fear of the slippery slope. The judges asked, if we allow this defense, who gets to decide who lives and who dies? On what basis? Would it be the strongest, the weakest, the least useful? The court feared that recognizing a necessity defense would become a legal cloak for unbridled passion and atrocious crime. In other words, once you open that door, you risk legitimizing all sorts of killings under the guise of survival. This is where we see the clash between law as a system of rules and law as a tool for justice in individual cases. The court prioritized the system. It decided that maintaining a bright-line rule, thou shalt not murder, even in the face of horrific circumstances, was more important than making an exception for these particular men. The message was, the law cannot be flexible enough to accommodate cannibalism, because doing so would undermine the very foundation of what murder means. But here's my first critical pushback. The court's reasoning feels morally tidy but humanly brittle. It's easy to lay down an absolute rule in a warm, wood-paneled courtroom. It's another to be in that lifeboat. By refusing to create a necessity defense, the court essentially said the law would rather see 4 people die innocently than allow 3 to live through a guilty act. That's a philosophically defensible position, but it's also a choice that prioritizes abstract principle over concrete lives. And it raises a haunting question. If the law is so divorced from human survival instinct, does it risk becoming irrelevant in the most extreme human experiences? This case is a textbook illustration of the great philosophical divide between utilitarianism and deontological ethics. The utilitarian calculation is coldly clear. 1 life sacrifice saves 3 net lives. That's a net gain of 2 lives. From a purely numbers-based perspective, it seems rational, even obligatory. But the deontological view, represented by thinkers like Immanuel Kant, says that each person has an inherent dignity and right to life that cannot be traded away, even for a greater good. Murder is intrinsically wrong, regardless of consequences. This is essentially the court's position. Parker's right to life was absolute. What fascinates me, though, are the nuances that get lost in that binary. Let's talk about consent. The custom of the sea traditionally involved drawing lots. That ritual introduced an element of fairness and mutual agreement. Everyone consents to the game, and everyone has an equal chance. In the Mignonette case, lots were discussed but never drawn. Why not? Perhaps because the weakest, sickest member was already selected. Parker, as the cabin boy, the lowest in the ship's hierarchy, was the most vulnerable. This wasn't a fair lottery. It was a selection of the most convenient victim. That changes the moral calculus dramatically. If lots had been drawn and Parker had consented, the act might feel less like murder and more like a tragic collective sacrifice. But without that ritual, it looks much more like a straightforward killing of a weaker party by the stronger. The court zeroed in on this. Parker was incapable of consent, and he was not party to any agreement. The lack of consent made it murder, not sacrifice. This leads to my second critical point. The court's judgment implicitly condemns not just the killing, but the failure of procedure. It suggests that maybe, if there had been a fair lottery with universal consent, the legal outcome might have been different. The judges don't say this outright, but the emphasis on the missing lots is telling. They were upholding not just the sanctity of life, but the sanctity of fair process. In a way, the law was insisting that even in the state of nature, some civilized rules must apply. We can't understand this case without placing it in its Victorian context. The British Empire was at its height, and a core part of its self-image was bringing order and civilization to the world. The custom of the sea was a vestige of a brutal, anarchic maritime past. The Victorian establishment was on a mission to stamp out such practices. Prosecuting Dudley and Stevens wasn't really about punishing 2 starving sailors. It was about sending a message. The Home Secretary, William Harcourt, was reportedly disgusted by public sympathy for the crew. He wanted a conviction to clearly establish that British law would not tolerate cannibalism, no matter the circumstances. This was the assertion of state control over the high seas and over the behavior of British subjects everywhere. There's also a class dimension here. Richard Parker was a teenage cabin boy, the lowest-ranking crew member. The case exposes the power dynamics of a ship, the captain's authority over life and death. By convicting Dudley and Stevens, the court was also subtly reinforcing that authority is not absolute. A captain cannot arbitrarily decide to sacrifice a subordinate, even for the supposed good of the whole. This geopolitical reading suggests the case was less about justice for Richard Parker and more about consolidating legal monopoly. The state was asserting that it, not tradition, not captains, not survival instinct, gets to define what is murder. This is a classic move of modern state building, replacing informal customary rules with uniform, state-enforced law. Let's be brutally honest for a moment. Most of us have no idea what we would do in that lifeboat. The moral theories we debate comfortably from our desks shatter under the weight of starvation, thirst, and the looming certainty of death. Psychology tells us that extreme stress narrows cognition. Decision-making becomes primal. The crew's discussions about lots show they were grappling with the moral dilemma, but in the end, the path of least resistance was to select the weakest. It's a horrifying but predictable human response. Group dynamics also played a role. The captain and mate formed a coalition, overriding the dissenting Brooks and the incapacitated Parker. Dudley's own account after the fact is chilling. We all was like mad wolves who should get the most, and for men, fathers of children, to commit such a deed, we could not have our right reason. He acknowledges a temporary descent into madness. This isn't a justification, but it's a crucial data point. The law judges actions, but it often struggles to incorporate this level of psychological extremity. This is where I think the court's judgment, while legally sound, feels psychologically naive. It treats the men as rational actors making a cold calculation, when by all accounts they were at the brink of physical and mental collapse. The law, in its quest for objectivity, sometimes fails to fully comprehend the subject, the human being breaking under pressure. The Mignonette case cemented the precedent that necessity is not a defense to murder in common law jurisdictions. It's taught in every introductory criminal law class for a reason. It establishes a wall that subsequent cases have buttressed. For example, in the famous hypothetical Speluncean explorers inspired by this case, the fictional judges grapple with the same dilemma, but the real-world precedent remains firm. This has profound implications. It means that in situations of extreme duress, whether a shipwreck, a mountain climbing accident, or a hostage situation, the law provides no safe harbor for killing an innocent to save oneself. The policy rationale is clear. Better to uphold the absolute value of life than to open a door to abuse. The dilemma of the Mignonette is startlingly relevant today. During the COVID-19 pandemic, doctors in overwhelmed hospitals faced horrific triage decisions. Who gets a ventilator when there aren't enough? The same utilitarian versus deontological debate raged. Similarly, programmers of self-driving cars must encode algorithms that decide, in a crash scenario, whether to prioritize the car's occupants or pedestrians. These are modern, technological versions of the lifeboat dilemma. The Mignonette case doesn't give us answers to these questions, but it gives us a framework for thinking about them. It reminds us that when we codify greater good calculations into law or code, we are making a choice that privileges outcomes over individual rights. The Victorian judges feared that choice. Our society is still wrestling with it. So where does this leave us? The Mignonette case is a landmark, but it's not the final word. It erected a high wall against the necessity defense, but that wall is constantly tested by new extremes, by pandemics, by climate disasters, by artificial intelligence. The core tension it reveals, between rigid rules and flexible mercy, between collective survival and individual rights, is a permanent feature of the human condition. My personal takeaway is this: the value of the case lies not in its legal answer, but in the questions it forces us to ask ourselves. It's a mirror held up to our own morality. Before you judge Dudley and Stevens too harshly, ask yourself, what would I really do? And before you dismiss the court's judgment as heartless, ask yourself, what kind of society do we want to live in? One where killing the weak can be justified, or one where the law holds the line, even at a terrible cost? There are no easy answers. But the struggle with the question is what makes us ethical beings. The men on the Mignonette were pushed beyond the limits of civilization. The law, in response, reaffirmed those limits. Both sides of that story are human, and that's what makes it a story we need to remember. If you found this deep dive into law, morality, and survival compelling, don't forget to subscribe, like, share, and hit the notification bell. This channel is all about analyzing the stories that shape our world. Thanks for watching. See you in the next one.